Sorry for the longer than usual delay.
The next case is 2010-0876 in the matter of Judith Raybeck and Bruce Raybeck.
May it please the court, I'm Joshua Gordon. I represent Judith Raybeck. As you know, her former husband cut off her alimony when he thought she was cohabitating, but really she was just house sharing. As you know, there's an enormous jurisprudence in this area.
But can I just ask you about some facts? Sure. They met on eHarmony, apparently. Family members referred to him as her boyfriend. There doesn't seem to be an issue about sharing hotel rooms when they're traveling, or I even thought sharing a bedroom at a family member's house on visits. So, appreciating that finances may have been separate and all, what do we do with those kinds of facts?
I think we can parse them. First, eHarmony, you know, you can meet somebody in a bar or playing mahjong or on a Sierra Club hike, and whether or not the forum is intended for romance, you know, you can use it for any purpose you want.
She admitted she dated him.
She dated him. She dated him. But apparently they're not romantically involved. So even if eHarmony itself as a corporate matter is intended, or hope that that's what its intent is, for these two, that's not what its outcome. They essentially found a housemate relationship or a friendship relationship, or however you characterize it, but they didn't find romance there. As far as the boyfriend statement goes, that's a statement of someone else. Now,
But isn't that reflective of how they hold themselves out? I mean, if her own family says, he's mom's boyfriend,
yes.
Aren't the parties responsible for conveying that?
Well, I think so, but there's two problems. One is it's not a statement she adopted. My client Judith expressly unadopted it. She says, "Well, we're fond of each other, but you know, he's not my boyfriend." And there is, I don't think it's clearly on the record, but because Mr. Raybeck has or potentially has a great amount of the wealth in the family, there's some hostility between my client and her family. She's not seen her children in years. So, you know, I don't know how much credibility that statement has, and I think the trial court understood these things, and it's why it discredited those.
Well, what does the vast majority of the body of jurisprudence to which you refer say?
Well, I think I quoted it in my brief I quoted the CJS encyclopedia. And, you know, that is, do they share living quarters? And here clearly yes. Is there continuous conjugal relations? You know, the only evidence is no. Do they hold themselves out as husband and wife? The only statement we have is this boyfriend. There is no evidence from neighbors or friends.
Well, you say, the only, for example, on the conjugal, the only direct evidence is no. I mean, we have some circumstantial evidence that might strongly suggest to the contrary, including the fact of the note, you know, we were going to get married.
Well, the note said we talked about it and decided not to. So that's as far as it didn't say I think there was an overstatement here. It said we decided not to. So that's as far as it didn't say I think there was an overstatement here. It said we talked about it and decided not to. The hotel room, you know, this was a way to economize. You can see how you want. One of the children they visited had a single bedroom, and what do? You know, there was an offer to sleep on the couch. It didn't work out, so they shared a room. They claim they're not sleeping together. It's the claim that the trial court believed that, and after all, it was the trial judge who saw the testimony.
Let me ask you, Mr. Gordon, what do you say about this time issue? In other words, if we affirm the decision below, does that prevent the husband 2 years from now from filing another request to terminate alimony because they're living together, because now 2 years later the terms of the contract
I fully expect he's going to come back. Maybe he'll hire a PI and, you know, find them holding hands or something. I don't know, but, you know, I fully expect he'll come back as much time. Now, there's only 3 years left on his alimony, 2015. so it's limited in some respect, but
So, but in other words, I guess what I'm getting at is you would, in my understanding, that you sort of concede that time can be a factor in the analysis of whether or not they're cohabiting.
well, no, well, yes and no. Time may be a factor if all the other standards are met, but, roommate relationships can go on for years and years and years, and it's still the same roommate relationship or housemate sharing relationship. There's no evidence here that they share this house in any way. They have separate bedrooms, separate bathrooms. They share a kitchen and a computer room. There's no evidence that, that they have access to each other's portions of the house. There's no evidence that her stuff ever got moved into his house. There's no evidence that she uses this address for her mail or for her voting or car registration. There's just very little evidence other than these between the lines of, they must be sleeping together, but that's really all there is.
Should we adopt a
split-level
test?
house that they share.
Should we adopt a test, or should we leave it to a case-by-case analysis of the trial court?
Well, I don't think it's
Or the legislature, for that matter.
there's three things going on there. If the Massachusetts test, I can see that's a well thought out test, but
Seems
it
to be.
also really looks like a legislative prerogative because from a common law point of view, it's a radical departure from what Mr. Raybeck back in Texas expected that he would be facing when he's talking about cohabitation. I don't think anyone expected that. So I think that's a legislative prerogative. Here, do you have to adopt a test or not? I mean, it would be convenient, but, what test do you adopt? There's so many. There's this general sense, like the CJS test or the Amjur test, and it's like, they're all pretty much the same. Conjugal relations are usually in them to some degree or another. And, then the third issue is, in this case, there's deference to the trial court, and these people in the late 60s, this is what they're doing, and I think you should just defer.
I thought it was interesting. In your brief, you say that the wife calls the individual she's living with, sharing a house, her best friend, but the relationship is not exclusive. Is she dating other people?
Yeah, that's
Was
what
there
her testimony
evidence?
says, that it's not an exclusive relationship.
But I mean, did
cited
she
that.
say, I am dating other people?
No, but it's not. She made clear. I don't remember the words specifically. She made clear that there was no expectation of exclusivity, which I think has.
She was keeping her options open, according to
She, looking for romance elsewhere, or not looking for it at all, or dating elsewhere. But there's no expectation of exclusivity among these two.
It's hard, it's some of that is hard to accept given it strikes me it would be a very unusual situation, to follow up on Judge Conboy's, that would be true, and yet when they travel, they sort of stay in the same room. It would have to be a very unusual situation, it would seem to me.
I'm not claiming this isn't a hard case. There's no question. This is in that gray area of the hard case. And, I think that's why this court's obligated to just defer because, it's the hard case. And I think there's really no grounds to determine otherwise. If that's all the questions,
Thank you.
thank you very much.
Case submitted. Counsel.